Governor, I have a question that was written from John Thomas Eves. Mr. Eves asked, do you think that the judiciary branch has too much power? If so, how would you address this issue as president?
Great question, and it's not that they have too much power, because the power is defined for them in the Constitution. The problem is that we have treated them as if they have more power than they have. This is the problem. If we actually adhere to the text of the Constitution, we don't have a problem. No, they don't have too much power, because they have the equal power of the other two branches. It's almost like all of us who took 9th grade civics learned a very fundamental aspect of being an American. We learned 3 branches, each equal. None of the branches were superior to the other. But somewhere between 9th grade, when we took civics, and getting out of one of those Ivy League schools, it's like we have become uneducated. And we've become more interested in what some professor of law has said, or what some court precedent has become, as opposed to what the actual text of the Constitution said. Let's go back to the origin. Let's go back to the founders, because their language to me is quite important. Jefferson was the one who made it very clear that if we believe that the court, specifically the Supreme Court, could issue a ruling, and that that ruling was final, and that it was the law of the land, as we often hear today, we hear it regularly. Jefferson said that in so doing, we would have surrendered to the doctrine of judicial supremacy, and that in essence, we would be under judicial tyranny. What he means by that is you now have nullified the other two branches of government by simply saying the Supreme Court can come out and say something, and that becomes the law, and there is no real argument other than going through amending the Constitution or impeaching the justices. Well, that is an extreme way to deal with what should be very simple. The courts make a ruling, the other two branches of government then have to engage to create the enabling legislation to put that ruling into place if they agree with it. I'm going to give an example. I was on MSNBC this morning talking to Joe Scarborough. They were pretty much all over me because I've taken the side of the county clerk in Kentucky who says that she does not have to fill out a marriage license for a same-sex couple, in part because the Constitution of Kentucky expressly says that marriage is between a man and a woman. The form that she is required to fill out for that marriage specifically has the language male and female. That law hasn't been changed. Now, if the governor of Kentucky brings the legislature into session and the people's elected representatives decide to change the form, if they decide to overturn their constitution, if they decide to make a lot of changes, then that clerk would, in that point, probably be required to either follow her faith and conscience law that has been enabled and enacted in her presence. Let me explain what I mean by that, because I think it's a very important point, Alan. I really can't emphasize this enough. The idea that the courts make a ruling and that's it, think about it. It doesn't make even common sense criteria. As a governor, I'll give an example. My state Supreme Court often made rulings. One was a very monumental one. It ended a 20-year court battle on school finance. The court ruled that school funding in Arkansas was both inequitable and inadequate. The two basic fundamental, I guess, tenets of education funding. I read the ruling. I said, you know what, they're right. According to the Arkansas Constitution, what the Supreme Court has ruled is 100% right. We are not in compliance with our Constitution. But the next day after the ruling, I didn't go around saying, it's the law of the land, and order the Department of Education to write new checks to 377 school districts in the state. Why? Because they didn't have the power to do that. The legislature had to convene, develop and pass a new funding formula that would tell how the money of the state taxpayers was to be distributed to those school districts. I had to sign that for it to become law, and after it was law, passed by an elected executive and an elected body of representatives, then I had the authority to order the Department of Education to change the amounts at which they were sending to the various school districts. Prior to that, I had no authority to do that because I didn't have the power of the purse, only the power of the sword. And the court had neither, so the court couldn't tell us exactly what that amount should be. And you know what? We don't want the court making that decision for us. We're living in a time where we have just sort of accepted this notion of judicial supremacy, and I challenge people, read the Constitution, not what someone said it said. Read it for its own words. Tell me where you find that. And when the clerk in Kentucky has taken the position she has, and I've been challenged saying, well, how can you defy us if she's not defying it? They say, well, she has to carry out the law. And my response is, quote to me the statute that she's going to have to follow. Quote to me the specific law. Because the Constitution says not one thing about marriage. Nothing. The Supreme Court reached out into thin air and created a constitutional right from words that aren't even in the Constitution, words like spirituality and intimacy, and based it on their cultural interpretation of what they thought it should be, not what the Constitution said it was. That's a role for the people's elected representatives to play, and if they vote differently, and the chief executive of the country signs it, now you have something that is the agreement of all three branches of government, and that's a whole new understanding. But otherwise, I think we are on treacherous grounds when we begin to just accept that the court's rule, that's it, move on, let's follow through. That is only valid when you have a cowardly executive branch and a cowardly legislative branch that will not follow its own responsibilities to do what it should do.